Hi, I'm Zach Anderson of Valley Estate and Elder Law, and I'm going to tell you about three Alabama probate rules that are just kind of squirrely. At least they're squirrely in my opinion. If you don't agree, let me know in the comments about why you think they're not squirrely. The first is no out of state personal representative or administrators. In Alabama, if a person dies a resident of Alabama and they have no will and they have assets that must go through probate, no person can be administrator or personal representative of that estate unless they live in Alabama. So you could have one child, no other family members, die a resident of Alabama. Your house wasn't in a trust or jointly owned or something like that, and you have to have that estate probated. Your child who doesn't live in Alabama cannot be the personal representative or administrator of the estate. I think this is a silly rule. I think it's probably outdated. I don't know exactly the philosophical underpinnings of the rule, but I would imagine it has something to do with back in the day, the closest family member, like physically to the person who passed away, might have had the best handle on what that person owed other people or owned, and that's kind of the essence of the probate. Now, with things like computers and the internet, that's not really true. And I don't find that to be true in my practice. But nonetheless, that's the rule. And it screws up all kinds of estates all the time. So now you know it. Number two is personal liability for personal representatives. So, personal representatives of the estate have personal liability. So, if you mess up and you're personal representative, not only can some disgruntled person suing you, whether it's a creditor or a fellow heir or a not heir who thought they should have been a beneficiary, they can come after your assets in the estate. They can also come after your personal assets through a lawsuit. Personal representatives in Alabama have personal liability, and that's a big deal, and you got to watch out for that. So you need to probably look at obtaining the services of a probate attorney, given that personal liability not being optional. The third and final thing is who the heirs are. That is, if you don't pass away with a will or a trust or something like that, and you didn't lay out a plan, the state of Alabama has a plan for you, and it's maybe not what you think it is. In one instance, consider if you have a spouse, no children, and your parents are still living. You might think the heirs, if I die without a will or trust, it's probably just my spouse. Wrong. Your parents could be heirs along with your spouse. It's actually more common than not that the parents would be an heir. It depends on the amount of money in the estate, but your parents could very well be heirs with your spouse. If you have a spouse, no children, and your parents are living. That's odd to me, and that's the third odd rule of Alabama probate that I wanted to share with you. If you're facing one of these oddities, give us a call. Let us help you with it. If you're not facing one of these oddities, give us a call and let us help you make sure that your kids don't have to face some of these squirrely rules with some of our estate planning services.